Sean Combs wants to know who the alleged victims are in his criminal case and the witnesses who may be testifying against him in May, but the prosecutors have doubled down and are saying not so fast. We're going to break down one of the latest responses from the government that focuses upon a major issue in this case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, we have a follow-up to a very important issue that is happening in the Sean Combs criminal trial, his prosecution. And this is Combs' request that the government disclose the names of the alleged victims and anonymous witnesses in this case. And now we have the government's response that we're going to get into. But before we even get into that, before I even address that, I have to lay all of this out a little bit so we make sense of what's happening. So first of all, we are rapidly approaching Combs' trial on federal charges of sex trafficking, racketeering conspiracy, and transportation to engage in prostitution. May 5th, 2025, out in the Southern District of New York. Before you know it, it is going to be here. And the government essentially alleges that Combs, for years, abused, threatened, and coerced women and others around him to fulfill his sexual desires, including participating in elaborate sexual performances, sometimes with commercial sex workers, and also to protect his reputation and conceal his identity, and that he would use the resources and employees of his business empire to create a criminal enterprise that engaged in all sorts of illicit activity. Now, for anybody who's been following this case, including right here on Sidebar, you know that a lot of this case has been shrouded in secrecy. We do not know the names of any of these witnesses, any of the names of these alleged victims. We have ideas about who these people might be, but we don't know for sure. We don't know specifics. We also don't know the specifics regarding certain alleged incidents, dates, times, locations. This is not surprising. This is common in kind of federal cases, particularly federal sex crimes cases, but we don't have a lot of information. And we don't even really know the full extent of what all the digital evidence is, right, in this case. And it seems, based on the defense's recent arguments, they have questions they need answered too. Again, I'm laying out everything to give you the context before we dig into this latest letter, or one of these latest letters from the government. So, back in October, Combs' attorneys, they filed a letter requesting the court, pursuant to the federal rules of criminal procedure, to direct the prosecution to identify the alleged victims in this case. They argued they have to know who these people are in order to properly prepare for trial. And what they asked for specifically was a bill of particulars. Now, we've talked about this on previous episodes of Sidebar before, but basically, a bill of particulars is a written statement outlining more details about a charge or charges that a defendant is facing. We see this come up a lot in terms of a criminal defendant's rights under the Sixth Amendment, namely to be informed of the nature and cause of the accusation. Hey everybody, we have another Law&Crime legal alert. The Los Angeles wildfires, they are still making an impact. It is estimated that these wildfires caused more than $250 billion worth of damage. The loss of life is just immeasurable, but there are reports that insurance companies canceled thousands of homeowners' fire policies in the months before the wildfires. Were those cancellations even legal? Will insurance companies be able to help people recover all that they lost? Well, I'll tell you what, Morgan & Morgan, America's largest injury law firm, they're here to help. They were there for the Northern California wildfires. They were there in Maui, and now they're here for you and the families affected by these horrific fires. So if you've lost loved ones, your home, your business, your property because of the Los Angeles wildfires, you can visit forthepeople.com/LCFire, and you may be entitled to significant compensation. Combs' defense argued that the need for a bill of particulars becomes especially important in racketeering or RICO cases. Why? Because that charge can be very, very broad. It can encompass a lot of different alleged criminal activity and underlying acts. So there is perhaps a need to particularize that charge more so than in other cases. You need specificity about what is being charged, what is being alleged, again, in order to properly defend myself, right, if I'm a criminal defendant. And in their October letter, Combs' defense laid out several reasons for why they say they need particularity, why they need a bill of particulars. First, they write, without clarity from the government, Mr. Combs has no way of knowing which allegations the government is relying on for purposes of the indictment. And they really emphasize that since Combs is facing accusations of sexual misconduct and wrongdoing in a number of civil lawsuits, so separate from the criminal case, civil lawsuits. Many people have come out and sued him, and by the way, many of which we've covered here on Sidebar. They argue that the government is basically forcing Sean Combs and his attorneys to play a guessing game about which allegations he's actually going to be forced to defend in the criminal case. We don't know. Second, his defense team argued, quote, given the anticipated amount of discovery and the expected time required for its production, Mr. Combs will be unable to adduce the identities of the purported victims from the discovery without the assistance of the government. Mr. Combs also anticipates that the discovery will contain voluminous evidence of consensual sexual activity, making it all the more difficult for Mr. Combs to ascertain which of his prior sexual partners now claim years later that they felt coerced. Even if it were possible to ascertain the victim's identity from the discovery, and especially given the volume of anticipated discovery, it's unfair to require Mr. Combs to spend significant time trying to unearth the alleged victims' identities. Again, goes back to the larger narrative. How on earth do we know exactly what the prosecution is arguing, what evidence they're going to introduce, which claims they're going to be focusing on, which alleged victims they're going to be focusing on? How is Sean Combs going to be properly able to defend himself if he doesn't know the specifics of this, right? Third, Combs' defense team highlighted the concern that was raised about him getting a fair trial, given all the publicity regarding those civil lawsuits that I mentioned. But more specifically, they argue that the plaintiffs in those cases and their attorneys, they're not restricted in statements they can make to the press and in the media in connection with those lawsuits, but Sean Combs is restricted from doing so. He's restricted from how he can publicly respond, because if any of that alleged misconduct in the civil lawsuits is actually also a part of the criminal case, and Combs and his team talk about it to the press, they could be in violation of a criminal rule that specifically warns attorneys and defendants to not make statements or release information that could be prejudicial or interfere with a fair trial. So Combs is basically arguing, I can't even defend myself in these civil cases because I might mistakenly say something about these civil cases that might be also included in the criminal case. This isn't fair. So big picture here, Sean Combs is like, I need to know more about what the government is alleging here. Okay. Now, the government responded back in October, and we're going to get to that a little bit later because it is connected to how the government just responded only a few days ago. But before we get to that, I have to tell you that just last week, the defense submitted another letter, and now they're saying they want witnesses' names as well, writing, the government has produced over 20 terabytes of information, and it is impossible to do a proper defense investigation as to the allegations in the Enterprise letter in less than 2 months without the names of the individuals, both alleged victims and potential witnesses who are listed in the Enterprise letter. Now, that Enterprise letter is very, very important. We were waiting for that. We were preparing to do a full Sidebar episode on that Enterprise letter because an Enterprise letter is filed by the government in RICO cases that more specifically lays out the exact allegations in the racketeering criminal enterprise charge, what evidence the government seeks to introduce to prove that, the specific underlying acts or events that make up that racketeering conspiracy charge. So we were prepared to do it. Unfortunately, we never saw it. Why? Because it appears that the letter was filed under seal based on the court docket. In other words, we, the public, can't see it. It's for the prosecution and the defense to know. That is probably for privacy, safety, and integrity of the judicial proceedings reasons, right? This was probably to ensure that details about the alleged crimes and potential alleged victims and witnesses' identities, they are all not revealed before trial because that could potentially negatively affect the case in some way. But in their letter from last week, the defense wrote the court respectfully, we seek a ruling from the court on our motion for a bill of particulars related to the alleged victims' names and also to the atomized witnesses in the Enterprise letter. So in other words, the defense, yes, they have more details about the racketeering charge and what the prosecution plans to do at trial, but they argue nonetheless, we still need to know who these alleged victims and witnesses are. So now comes the prosecution's response, and that's what we want to get into. So in this letter that is dated February 21st, 2025, the government writes, The government writes in response to the defendant's letter asking the court to rule on its motion for a bill of particulars, originally filed on October 15, 2024. The government continues to oppose the motion, which was originally styled as a request for a bill of particulars identifying victims and has now been apparently broadened to encompass not only victim names, but also the names of a large number of potential government witnesses. The defendant provides no persuasive basis for his request, which in any event will be fully satisfied when the government provides the information on the schedule already set by the court, and the request should accordingly be denied. They go on to write, for the reasons set forth in detail in the government's October 30th, 2024 opposition to the motion, premature identification of victims and witnesses carries significant risks in a case like this one, which involves numerous allegations of violence, coercion, obstruction of justice, and witness tampering. So, what did the government, the prosecution, argue in their opposition back in October? What were the risks? First of all, as the prosecution wrote in October, quote, courts routinely reject requests for victim identities in cases involving crimes of violence and racketeering, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subornation of perjury. And here, the prosecution argued there is, quote, serious, well-supported allegations of prior attempts to obstruct and tamper with witnesses, basically on the part of Sean Combs. In fact, they cited the ruling from a prior judge who denied Sean Combs bail, writing, quote, having found by clear and convincing evidence at the conclusion of the second hearing the defendant is a danger regarding obstruction of justice and witness tampering and is a danger to the safety of others in the community more generally. And we all recall prosecutors have alleged that Combs tried to improperly contact witnesses while in federal lockup in the MDC, the Metropolitan Detention Center, where he's been since his arrest and indictment in September of last year. And as reported by outlets like NBC, there was also the allegation that Combs tried to influence the account of a potential witness in the civil case of Dawn Richard, a former musician in a Sean Combs-created band that has since sued the rapper for sexual misconduct. So the government wrote in its October opposition, due to the defendant's history, the government has serious concerns about victim safety and the possibility of witness tampering if a list of victims' names were provided to the defendant. And that seems to be echoed once again by prosecutors in this most recent letter to the court. By the way, in this new letter from the prosecution, they also cite the infamous case of R. Kelly in support of their argument. Remember when R. Kelly was convicted in New York federal court of his own racketeering case for the sexual exploitation of children, forced labor, and transporting women and girls to engage in illegal sex acts? Well, the prosecutors in Sean Combs' case, they're telling this judge, Judge Arun Subramanian, who's overseeing Sean Combs' case, they say, look what happened in R. Kelly. In R. Kelly, the court rejected his request for a bill of particulars identifying the victims' identities because of his own history of obstructing, intimidation, and witness tampering. Essentially, they're saying the same thing is happening here. Okay, so now let's go back to this recent letter from the prosecutors, from the government, from February 21st, this letter to the court. And again, this is where the prosecution argues that the defense is not entitled to a bill of particulars identifying victims and identifying witnesses. So after citing how identifying these people carries a risk, the government then writes in its letter, quote, moreover, since filing the motion, the defendant has received substantial additional disclosures, including terabytes of Rule 16 discovery, which provide him with more than sufficient information to prepare for trial. Most relevant to the instant request on February 1st, 2025, the government provided the defendant with a 16-page enterprise letter outlining in detail the racketeering activity and related conduct that the government currently expects to prove at trial in connection with the charged racketeering conspiracy offense. The enterprise letter described these acts in detail, including their approximate dates and the people involved, noting, for example, their titles at the defendant's company or providing other identifying features. In short, these additional disclosures undermine any claim by the defendant that he is not aware of the nature of the charge pending against him or is unable to adequately prepare for trial. So that's the prosecution kind of responding to a Sixth Amendment violation argument that I mentioned before. Now, again, we've talked about the enterprise letter. I mentioned it before, but basically prosecutors are like, Sean Combs, you got enough information right now to properly prepare a defense at trial. There's also a footnote in this letter that reads, as previously communicated to the defendant, the government will supplement the enterprise letter in the event that additional incidents are identified or if the government obtains additional material information about the conduct described. So that's kind of in the spirit of an ongoing investigation. This racketeering case could enlarge him. But they continue, instead, the defendant's renewed request for a bill of particulars is merely an attempt to relitigate the pretrial schedule to get even earlier disclosure of victim and witness information. But his assertion, meaning Sean Combs' assertion, that such information would be useful is no basis to grant his request. Let's talk about that for a second. Let's talk about that schedule. So the government argues that in the lead up to trial, they will furnish a witness list by April 14th, 2025, 3 weeks before trial, and that this was already set by the court, and that there's no need to provide more information about witnesses prematurely, not right now. And also, prosecutors say that those witnesses' prior statements will be disclosed to the defense by March 21st, 2025, so more than 6 weeks before trial. That was also set by the court. These witness statements, we call these 3500 material or Jenks Acts material. But in other words, the prosecution is saying there is no need for a bill of particulars defense because you will get all of this information before trial anyway, and you will have adequate time to prepare. And by the way, this was already echoed by prosecutors in their opposition from October, the one that I've been talking about, because that read in part, quote, but notwithstanding the defendant's procedural failure, the motion also fails in the merits because there is no need for a bill of particulars listing victims' names here. The defendant has been more than sufficiently apprised of the nature of the charges he faces based on the 14-page speaking indictment, the government's written submissions and factual proffers at 2 separate bail hearings, and discovery produced to date totaling over 25 terabytes of data, including detailed search warrant affidavits laying out details of the government's investigation and evidence. Courts have repeatedly rejected requests for bills of particulars where the defendant has received similar materials. Basically, you got enough. Now, going back to the current letter, again, the one that was filed just a few days ago, prosecutors in this letter, they argue that all the defense is trying to do is relitigate a pretrial schedule that has already been set by the court. And they cite case law in support of that. More specifically, they cite one case that apparently held that a bill of particulars should be granted where it is necessary for the preparation of the defense, but not merely useful. That's not enough. And prosecutors argue that while Sean Combs claims it's impossible to do a proper defense investigation as to the allegations in the enterprise letter in less than 2 months without knowing the names of the individuals, meaning the victims and witnesses, the prosecution makes the point, quote, defense counsel does not explain why such a task is impossible, particularly when it has the detailed information set out in the enterprise letter and in prior disclosures. Under the law, merely saying that a bill of particulars is necessary does not make it so. And they actually cite another very high-profile case from a New York federal court that took the news a few years back in support of their argument. They cite the case of Keith Raniere. We remember him, the founder and leader of NXIVM, sentenced to 120 years in prison after being convicted in 2019 of racketeering conspiracy, sex trafficking, attempted sex trafficking conspiracy, forced labor conspiracy, wire fraud conspiracy. And they cite the case of Keith Raniere because apparently Raniere didn't carry his burden to show that a bill of particulars was necessary, that his claim that the government provided mountains of documents with little guidance as to which ones were relevant to the case, that was not a legally sufficient reason to justify a bill of particulars. So in the end, the government ends the letter writing, accordingly, for the reasons listed above and those set out in the government's prior opposition brief, this court should deny the defendant's motion. Now, it seems based on the pretrial schedule and the enterprise letter, there is a strong chance the court will deny Sean Combs' motion for a bill of particulars at this point. They may find it too risky, too unnecessary to reveal the names of witnesses and victims at this point. And again, the court does have to ensure that Combs can adequately appreciate the charges and can properly defend himself. So we shall see, but I will say one more thing. I am reminded of something that prosecutors mentioned in their October opposition too, because they wrote at the time, quote, When a defendant seeks victim identities through a bill of particulars, courts generally deny disclosure if the government sets forth specific reasons why such a request should be denied. And prosecutors here in Combs' case could argue, we certainly have done that. They also wrote in that filing, in particular, courts routinely reject requests for victims' identities in cases involving crimes of violence and racketeering, especially when the government demonstrates a risk to witness safety, the potential for witness intimidation, or subordination of perjury. We talked about those issues in this case. And they also wrote, quote, courts also routinely deny requests for bills of particulars containing victim names on the basis that these requests are in reality a backdoor attempt to obtain a list of the witnesses whom the government intends to call at trial. That's especially important because the witness list has been scheduled to be disclosed in the near future, so there is a strong chance the court will deny Sean Combs' request. But I will also add this. There's also another argument that was mentioned by the government in their October letter on this issue that was of note, may come up again. I just want to mention it real quickly because they argued that granting a bill of particulars may negatively affect their case, may negatively affect the prosecution's case. How so? They argued they would be unnecessarily restricted in what they can present and prove at trial. The prosecutors wrote in their October opposition, quote, the defendant's request would also have the effect of improperly foreclosing the government from using proof it may develop as the trial approaches. Why? Because they explain that a bill of particulars confines the government's proof to the particulars that are furnished. In other words, the government's presentation of evidence at the trial is limited to what is laid out in a bill of particulars. And the argument is, this can improperly restrict the government's ability to present its case and from using evidence as this investigation continues. The prosecution wrote, quote, the defendant is alleged to have participated in a multi-year conspiracy, and as the defendant is well aware, the government's investigation of that conspiracy is ongoing. Accordingly, it would be entirely inappropriate to force the government to commit over 6 months before trial to whom it will present at trial as a victim. Now, this is again filed in October, so it's a bit of a different situation now. We're in February, but the prosecution's main argument is a bill of particulars could improperly restrict the government, and they say that's not right. That's not the purpose of a bill of particulars, and that's why courts have to use great care and caution before ordering a bill of particulars be produced. And they cite case law in support of that too. Like there was one case that apparently held, quote, the vehicle of a bill of particulars must not be misused to compel disclosure of how much the government can prove, nor to foreclose the government from using proof it may develop as the trial approaches. And prosecutors also warn that the government's bill of particulars creates the very real danger that a defendant will tailor testimony to explain away the government's case. So it's a really interesting argument. Again, this was from October. The case has progressed significantly since then. I mean, we now have a superseding indictment since that time. So you wonder, even if the government were required to disclose a bill of particulars, whether that would unnecessarily or improperly restrict their case at this point when we're so close to trial. Is it not already almost set in stone? But at the time of this recording, no word yet on this bill of particulars issue. We'll keep a very careful eye on it. But that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.